The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court, now sitting.
Please be seated. Good morning and welcome to the Kansas Supreme Court. As you can see, the Chief Justice is absent today. He had a family medical emergency arise late yesterday and has had to leave town to deal with that. And so he will have access to the recordings of the hearing, the oral arguments today, and will fully participate in the decision-making on the cases. So with that, I would ask the clerk to call today's docket.
Appeal number 109,015, Nationwide Mutual Insurance Company versus Briggs and others. Certified question, brief both sides.
Chris Sweeney on behalf of the appellants. Trent Church on behalf of the appellee Nationwide.
Teresa Sheehan Hall on behalf of the appellee Nationwide, and I will be arguing the case.
Appeal number 103,020, Busman versus Safeco Insurance Company of America on petition for review, Neosho County, brief both sides.
Paul Hasty for the defendant, appellant and cross appellee.
Fred Spigarelli for the plaintiff, Mrs. Busman, and appellee.
Appeal number 106,093, State of Kansas versus Lewis, Bryan County, brief both sides.
May it please the court, Rachel Pickering, the Appellate Defender Office, on behalf of Tony Lewis, present and ready for argument.
Barry Wilkerson, Raleigh County Attorney, present for appellee, arguing on behalf of the state.
Appeal number 106,150, State of Kansas versus Sharkey, Jeffrey County, brief both sides.
Michelle Davis on behalf of the appellant, Mr. Sharkey, and Ray Harden.
May it please the court, Assistant District Attorney Boyd Isherwood on behalf of the state of Kansas, present and ready for argument.
Thank you, Ms. Green. That will call the first case on the morning docket, Nationwide Mutual Insurance Company versus Briggs.
Good morning. Chris Sweeney on behalf of the appellants, the children of Melvin Briggs. I would request 5 minutes for rebuttal.
5 minutes, granted.
Thank you. Melvin Briggs was killed in a car accident caused by an uninsured motorist, and his children brought an uninsured motorist claim against Nationwide Insurance Company. Nationwide denied the claim, asserting that they had non-renewed the policy 8 days before the car wreck. The case comes before this court on a certified question from the 10th Circuit. The Federal District Court granted summary judgment to Nationwide and found that it is unnecessary to determine whether or not the ground for non-renewal was appropriate. All that was necessary was a proper notice. And so the 10th Circuit's question to you all is that enough? Is proper notice enough? And specifically, or exactly what the 10th Circuit has asked is, under Kansas law, is proper notice sufficient to non-renew insurance coverage regardless of whether there is an authorized basis for non-renewal under the policy or KSA 40-276A? Many years ago, this court addressed what is necessary to terminate the insured-insurer relationship. And in that case, Harrison versus Farmers and Bankers Life Insurance Company, this court said to terminate that relationship, you must comply with the terms and obligations of the policy. The only way to terminate the relationship is in compliance with the terms and obligations of the policy.
I want to talk about what those were.
Pardon?
I want to talk about what those were.
What the obligations of the policy are. Exactly. So that's what the court says we need to look at.
Okay. So what term of insurance did Mr. Briggs bargain for?
So the terms he bargained for was
what term? What length of time did he bargain for? How long was the policy in effect? Had the insurance company done nothing, how long would that policy have been in effect?
Well, the policy is automatically renewing unless they issue a non-renewal.
Okay.
And so
automatically renewing each year is your position.
Correct. All right, and so the term that he bargained for was this: in exchange for this premium that Nationwide had determined the amount of, in exchange for that premium, we're going to give you this policy that will automatically renew unless we non-renew, which requires this. First, we have to send 30 days notice, 30 days ahead of the non-renewal. But that's not all they had to do. They said, they promised, we would not non-renew. We won't non-renew.
Well, that's
your
the
policy.
question, is what did they have to do, not why they did it. And my problem is the procedure for non-renewal is this and such and basically the notice. You're saying that they have to have a good reason to do it. I have a logistical problem. How does that get proved by the end of the term of the current policy?
Okay, so
you're saying that you have to have a good reason that fits within the statute, but obviously they thought they had a reason. You dispute that. So you're saying that until that's resolved, maybe 5-10 years later, whatever, if it goes wherever it goes, that policy stays in place until you have an adjudication of whether that was a proper?
no, and if that's the argument that it sounded like I was making in my brief, I apologize. They've non-renewed the policy. If that non-renewal is contested, as in this case, and their ground for non-renewal was insufficient, then the policy remains
according
enforced.
to whom? Insufficient according to whom?
According to their policy. It's not.
The problem is he's asking a practical question. You're arguing theory, and he's asking a practical question. How does it work? Is all that's necessary is for the insured to contest whether there is a valid reason in existence in order to keep the policy in effect while that contest is decided?
No, I don't think so at all. But what would happen is, practically, is if there was a determination made that the ground on which they relied to cancel.
But who makes it? Who makes it?
The court does.
Right.
So,
and how long is that going to take? That's my question.
Yeah, I don't know how long it would take. However,
so the insured, as long as the insured has bargained for a policy that automatically renews, unless there's a valid reason in existence for non-renewal at the time of non-renewal, or at the time of notice for non-renewal, the policy continues indefinitely until a court has issued a ruling on whether there was a valid reason in existence.
No, I mean, two reasons why that wouldn't be the case. But
okay.
First, if it was a valid reason and it was determined by the court 10 years later, the policy then was non-renewed 10 years ago when they non-renewed it because they had a valid reason under the policy. So it doesn't continue in effect for that 10 years while we're waiting some determination.
Okay, so in order to be compliant with Kansas law and carry automobile insurance, your insured would have to have gotten a second policy to cover in the intervening time while the court makes up its mind?
I think
under your policy, I think it says if the insured has obtained different coverage, then the policy ends, doesn't it?
Exactly, and so a prudent insurer probably would take exactly that course of action where I've been non-renewed, I don't agree with this non-renewal.
But while I fight about it, I better get some other insurance.
I may go look for other insurance. And they may not. They may take the chance that I am 100% right. They're just wrong about this non-renewal. I don't need to go get other insurance. But others may say, well, I got a chance of...
And if you're wrong, do you go to jail for failure to follow the mandatory insurance laws? If the insurance company wins and their non-renewal was appropriate and we're 5 years down the road, then you've been in violation of Kansas law because you haven't had valid insurance for 5 years?
Yeah, I don't know whether I would go to jail in that scenario. Whether or not I have violated the law, I would say, yeah, if I didn't have valid insurance.
Well, we do have some constraints that we're not to construe either statutes or contracts to be completely ludicrous. And I'm trying to find out why this isn't ludicrous to say that the insurer has to prove appropriate grounds before the policy actually non-renews, especially when an action for breach of contract, your damages would be to get what you would have had if they hadn't breached the contract, and you're at the same place as if there was a policy in place, aren't you?
Right, so if my remedy under a breach of contract is to be put in the same place I would have been but for the breach.
Well, that's
Right.
what I'm saying. If it non-renews and the policy no longer is in effect, but you breached the contract because because the insurance company improperly non-renewed, the insured sues, and that insured's damages are to be put back in the place they would have been if the coverage had been in place. So why are we arguing about whether the policy continued? Because you get to the same place.
Well, and I guess I don't know that I understand how I can have a breach of contract claim. If I can be put in the same place, and that same place is the non-renewal never happened. I'm in the place where that non-renewal didn't happen, and so I still have coverage. And that's why I can bring the breach of contract claim. If the non-renewal was effective, I don't have coverage. I have no breach of contract claim to bring because the cancellation was effective. There's no benefit that I have under the policy anymore. And so the only way for me to have
The
that.
difference is that there's no coverage during the pendency of the adjudication of validity. That's the main difference. You're saying you want it to cover and continue until you have an adjudication of the propriety of the reasons versus suing for breach and having that determination while your insured goes off and does something else.
Yeah, I really am not saying that. I'm really not
Okay.
saying that it automatically, simply because I've contested the non-renewal provision, that automatically my coverage extends. I'm not saying that at all. What I'm saying is, if they non-renewed for an invalid reason, the non-renewal was ineffective, and so, therefore, my coverage did continue. I'm put back in the same place that I would have been but for the breach. If they were right, I'm not put back in that place. The non-renewal was effective, so coverage didn't continue over that period of time.
You're saying effectively you've already sued for breach of contract.
Pardon?
You're saying that effectively you already have
Well,
sued for breach of contract.
We didn't really get a chance to sue, right?
No, you got.
Because Nationwide sued us first.
But your position in declaratory judgment action is that you have a breach of contract.
Right. And so if you roll reverse and say, okay, we got the chance to bring the action first and we brought a breach of contract, their affirmative defense would be this, well, we non-renewed you. And they would have the burden to prove that non-renewal, and we'd be arguing it the same way except on different sides of the V.
But none of that, I mean, this is a certified question, so we have a rather narrow issue in front of us, which is whether either your policy, I suppose, or the statute, or the two of them read together require the notice to include the reasons for renewal, right?
Okay, and
I mean,
again,
so, and when we started going there earlier, and I would like for you to talk about what's the statutory basis for your argument?
Well, the statute says that an insurance company cannot non-renew unless 6 circumstances, one or more of 6 circumstances exist. So that's the statutory basis. My argument is.
But what is the statutory basis for your argument that the notice has to include the reasons?
We're not making that argument.
I'm sorry.
The notice doesn't have to include it.
Okay, I misunderstood then. Okay.
Right, and that's the way it is cast in
Okay.
the appellee's brief. But the notice has to provide what the statute says, and the statute doesn't require the reason being there.
Okay.
But then another statute says, here's the only reasons why you can non-renew.
Right.
And so if you renew for any reason other than one of those 6, your non-renewal is no good because the statute says you can't non-renew for any grounds other than these. But it doesn't have to be in the notice. We're not making that argument.
Okay, all right.
All right, I'm out of time, but I'm glad to answer any other questions.
May it please the court, Teresa Hall for the appellee Nationwide. To get back to the point that was being made with the appellant's counsel, I think they are arguing that the notice has to include the reason for non-renewal, and that somewhere down the line there has to be judicial determination that the reason.
I think they're arguing the second thing. They're not arguing it has to be in the notice. I mean, he just said they're not. They're arguing that there has to be a determination made. I have a question for you, counsel. Do you agree with your opponent that if no notice had ever been sent, that the policy would have automatically renewed year to year?
No, I don't agree with that in that.
And can you point us to some place in the policy where that language does appear or doesn't appear? It should be if it was correct. I mean, just tell us where in the policy we should look.
What I base that opinion on is that a policy is set for a period of time set forth on the declarations page. A premium's assessed for that coverage for those risks during that time period, and it's contingent upon a premium being paid to cover that risk. If a premium's not paid, that policy will not automatically renew.
Let me revise my question. Assuming the premiums are paid. There's no allegation in this case that premiums were unpaid, is there?
No, there isn't.
Okay, so let's assume that Mr. Briggs continued in his original pattern and he continued to pay his premiums in a timely fashion and in full. Would the policy automatically renew every year as long as that condition continued and you had not sent, your company had not sent a notice of non-renewal?
As long as the conditions in the policy and the contract between the parties were fulfilled, premium paid, then the policy would renew and continue with coverage for that policy period that's agreed upon by the parties.
Even if premiums are not paid, the company's required to give notice of non-renewal.
Correct.
And so you can have non-compliance and still run over the specified term on the deck page until you can give your 30-day notice.
Correct. And again, that's a set time period, unlike what they're arguing in this case, is that as long as there's an allegation or contention that a non-compliant reason was behind the non-renewal, coverage goes on indefinitely until there's a judicial determination that that notice was for a compliant reason.
Let me ask you this, counsel. Do you agree with your opponent that if the court were to say that the non-renewal procedure followed was appropriate, they still have a claim for breach of contract?
Definitely. The relief lies in, as stated by Judge Waxy, and let me digress for just a minute. The facts in this case showcase why Judge Waxy correctly ruled that the question of notice and termination is completely separate from the question of what's your relief if it turns out that the reason that they terminated was wrong, that they non-renewed was wrong. What's your remedy for that? The remedy isn't that you have perpetual coverage. There's nothing in the Kansas law that provides for perpetual coverage. Under Kansas statutes, your relief lies in the Unfair Trade Practices Act, which specifically says violation of 276A, the reasons, is an unfair or deceptive trade practice that can be prosecuted by the Department of Insurance or breach a contract with statutory penalties for insurance fee or for attorney's fees should the denial or the non-renewal be inappropriate or a breach of the contract based on that finding. The facts in this case, after the accident, the defendants filed suit against the insurance agent and the insurance agency alleging no policy was in effect because of the non-renewal by Nationwide. Armed with the notice of non-renewal, they filed suit against the agent saying because of his negligence in failing to obtain replacement insurance, Mr. Briggs was uninsured at the time of the accident. Shortly after that, they make a claim against Nationwide stating your notice didn't show proof of a compliant reason, therefore your policy's still in effect, Nationwide. Nationwide files the DEC action on the
Isn't this just an argument in your defense of a breach of contract action?
No, and it just shows
and why do we care about that on the certified question today?
It shows why the argument they're making is without basis, and the problem such an argument can cause when and they argue that the policy still continues even though they've already made a claim against the insurance agent for the fact that there was no insurance at the time of the accident, can recover $500,000, the limits of the uninsured motorist coverage under the Nationwide policy, and then pursue a claim against Nationwide saying, well, you never gave a proper reason, so you're still on the hook. According to the Briggs, today our policy is still in effect. You know, so many years after the accident, until there is a judicial determination whether or not our reason was compliant, the coverage is still in effect. That is their argument. Judge Waxy correctly, we believe, ruled that the question whether coverage terminated at the end of the policy period was based on giving proper notice. The reason, or the non-compliant reason, would only affect what remedies are available to the insured if there's a determination made that it was the termination was for an improper reason. The termination itself is not dependent upon the reason. If the reason's wrong, there's breach of contract, there's unfair claims practices, those are the remedies, not perpetual coverage until a determination is made.
I guess that's why I read the certified question as not going to the remedy. That's the breach of contract issue that you're litigating, but as going to what is proper notice and what actually will terminate the insurance.
Right, and I think the question intermingled, melded the two issues into one. So the answer to the question would be, yes, coverage does terminate regardless of whether there's a compliant reason, but the non-compliant reason is addressed by the Kansas legislature in the Unfair Claims Practices Act, or remedies brought for the fact that there was non-compliance with the policy, breach of contract, and then the statutory penalties. That they're not one and the same. They can't be, as Judge Waxy pointed out, one is whether there's termination, the other is what is the insurance company subject to if they wrongfully made the decision and they wrongfully denied or non-renewed the cover.
Your point is there's a procedural point and there's a substantive point. And you all are arguing procedure in this case. And substance is for another day in another kind of proceeding, either an unfair trade practices proceeding of some sort or a breach of contract proceeding, but it's not today. We're just talking about procedure today, basically. The procedure for non-renewal. And you followed the procedure. You sent notice that was appropriate, had appropriate content within the appropriate time frame.
Exactly. And that
here's my question for you. Isn't it true that procedure is in the service of substance? I mean, that's why we have procedure, right? In order to achieve the substance of what we want to achieve.
And so I would qualify my response to your previous question. I think it's a mixed question of substance and procedure.
Well, I agree that the question as posed melds the issues, and that's a problem that we're going to have to deal with in answering it. But your argument's about procedure, and you want to focus on procedure, right?
Okay.
I mean, is that true? You're focused on procedure for non-renewal.
According to the statute and the policy, insurance company jumped through these hoops to get from A to B.
Right.
If you comply with these procedures and provide this notice, coverage terminates.
And I'm sorry if I've been confusing. I'm identifying substance not as the outcome in this case, but as the reasons that you have to have for pursuing the procedure. And the reasons are stated in the other subsection of the policy in the statute, correct? The various reasons for valid non-renewal. That you don't want to talk about. You don't want to talk about that in this proceeding. You don't want to talk about whether you did or didn't have a good reason in existence at the time.
That's not an issue in this action.
Exactly. That's your position.
Yes.
Okay.
Yes.
At what point does the reason you can do something become a part of the process for doing it?
I would say if there's a statute that says, like in the other states that are in our brief, where the statute says, insurance company, not only do you have to do A, B, and C, but here are these reasons that we have enumerated as those are the proper basis, you have to show in that notice or in
Do
conjunction
you think
with that
line
notice.
is drawn when you have a statute that requires it to be in the notice?
Yes.
Okay.
Under Kansas,
Which is
under previous Kansas precedent, the Felt case again, and followed by the Spencer case, as quoted by Judge Waxy, the value in those cases is that the courts say, okay, you have a public policy argument, but we're confined to what the legislature has told us you have to do, and if you comply with that, and there's remedies provided by the legislature, specifically this violation of this 276A, the compliant reasons, it specifically says you can go to the Department of Insurance and file a complaint. They can assess penalties, other kinds of remedies. You can bring a breach of contract action to put you back to where you should have been. But for the argument to be made that there has to be a judicial determination every time there's a non-renewal or a cancellation before that becomes effective, and years down the road, as they are arguing in this case, years down the road, there's still coverage in effect, there's just no basis for it by the legislature or the decisions of this court that have looked at these questions in the context of what the legislature has directed.
And in your view, is following the procedure that you outline, is the injured party or potentially injured party made whole? Do you think the remedies are coextensive?
Yes, definitely.
They're actually
Coverage,
more. They're actually more.
Because of the penalties?
Because of the penalties.
Correct. And plus, in
attorney's
terms of
fees.
being made whole again, and I'm not sure how, hasn't the defendants in this case been made whole? They recovered $500,000, the uninsured motorist limits.
That's the argument for the other case, though. Again, you're going back into defending the breach of contract action, and you're saying they don't get breach of contract remedy in this case.
I bring it up in terms of they seem to be making a public policy argument that, as they said in there, if this court finds that you don't have to comply with 276A, one of those reasons, insurance companies can deny or non-renew for any reason. It can be based on race, gender, there's no constraints on what an insurance company can do. So from the public policy aspect that they're arguing, that as a matter of public policy, the statute should be read as requiring notice with a compliant reason. From a public policy standpoint, I think that's a very important point as to why the fact that they did recover, were made whole, should be taken into consideration.
And as a practical matter, upon non-renewal, the insured is relieved of the obligation to pay the premium.
Correct. And I would just add, in this case, again, highlights the problem with arguing, well, you just go out and get another policy, and then the coverage will terminate arguably under the policy that was non-renewed for a non-compliant reason, and there's coverage in place. And in this case, the insured is deceased. The insurance agent never got a replacement policy. So how this policy, Nationwide's policy, is still in effect according to the defendants in this case.
Yeah, that's a complicating factor here.
I would, in conclusion, I would just say that there is no, unlike other states, there is no Kansas statute that provides for that ties the reason for the non-renewal with the notice and termination of the coverage.
In the posture in which this case is before us, a certified question, is your answer a simple yes? the question is, under Kansas law, is proper notice sufficient to non-renew insurance coverage regardless of whether there's an authorized basis for non-renewal under the policy or KSA 4276A?
Yeah, Nationwide respectfully requests that the court respond to the certified question in the affirmative, and that under Kansas law, as it's stated by the legislature, if proper notice is provided to the insurer, the policy will not renew at the end of the policy period.
So your answer is yes?
Yes. And we're asking, and Nationwide is requesting. And I would just conclude with Judge Waxy's statement in his opinion, ruling in favor of Nationwide, that without any Kansas authority indicating that violations result in perpetual coverage, this court will not hold for the first time that allegations of violations of 40-276A result in perpetual coverage ad infinitum under Kansas law.
And your definition of proper notice is simply one that complies with those things set out in the statute, and which does not include a reason for non-renewal.
Correct. And again, I would just add, looking at the statutes from other states, they set out the procedure for if notice and a compliant reason is required, what's required, how that notice is provided to the insured, and what the consequences are if that notice is not provided. Absent that language in a statute by the Kansas legislature, I submit that the answer to this question should be yes. Thank you, Your Honors.
May it please the court. Maybe it's the semantics of it that I'm getting hung up on. Is proper notice sufficient to non-renew? And y'all are talking about we have a breach contract action. If they effectively non-renewed the policy, there is no breach contract action. They non-renewed, there was no
Well,
coverage.
that's not true. If I'm kicked out of my apartment and that was contrary to the lease, okay, I'm out of there. They've terminated my lease agreement, but I got a cause of action for breaching the lease agreement, and here there's cause of action for having breached by failing to provide the coverage that they were supposed to, or the notice that they were supposed to.
Exactly. So if they were to provide the coverage they were supposed to, maybe the notice was sufficient, but they didn't actually terminate the coverage. The coverage still existed at the time.
It is a matter of semantics. It's a matter of whether the aggrieved person has to prove a breach and get a remedy, or whether the insurance continues for all insureds until the insurance company takes the additional step that is nowhere to be found in the policy or in the statute of adjudicating a valid reason, right, or proving a valid reason.
And I want to make it very clear that we are not saying that the coverage just continues indefinitely, and that so long as this action is going on, coverage just rolls on. They know the reason they terminated coverage. They know it. They're the ones who did it. They know whether it complies with the statute. So either the termination was effective when they did it because it complied with the policy and the statute, or it wasn't. They know. Okay? And so if it did comply with the statute, termination was effective when it happened, not just because we were contesting it. Does it continue on? It was effective immediately. If it complied with these terms. This isn't something that I'm making up. I mean, this court in Greyer said it's not just the procedure that must be followed to terminate a contract. The substantive reasons must be followed as well. It's not just the notice that must be followed. The grounds for termination must have accrued.
Let me ask you this. Let's say they did have a valid reason. If I recall, one of the reasons is that you've been insured for more than 5 years, and or some innocuous reason that's easy to prove, and they were absolutely 100% in the right, both statutorily and under the contract, when did the policy coverage terminate? If they gave proper notice and they had a valid reason, when did the coverage terminate?
8 days prior to the wreck. Yeah, it didn't, just because we contested it, didn't cause it to continue on.
Okay.
And we're not saying that the reason has to be in the notice, because no statute says that. What we're saying is what the Grier Court said, and that is there are two things that have to happen to terminate the policy. Proper notice and the grounds must have accrued. And there's no attempt, none at all, to show that the grounds for termination have accrued. Now, if you answer this question, yes, proper notice is sufficient to non-renew, there is no breach of contract claim, because there is no coverage at the time of the wreck. They haven't denied us any benefits.
You're saying there wouldn't be any damages from your breach of contract claim. You can always bring one.
It'd be there are no
Wouldn't have
basis.
damages.
Would
The
have no
argument would
legal
be there are no
basis for it.
damages. Yeah.
Well, no, but it's beyond that. What I'd be saying is, on September
I understand.
11th.
I understand your argument.
Yeah.
Yeah, I understand your argument. Your opponent's just told you to sue them.
Exactly.
If
But
this was, she's
because
just
she
told you that there is a breach of contract.
Because she knows that if you all answer this question, yes, that the termination was effective, then my breach of contract claim is nothing. I can't bring it because there was no coverage at the time of the wreck. There are no benefits for which they have denied me that I'm entitled to. And so
Why aren't you still able to bring a wrongful termination breach of contract suit?
So, yeah, I guess I don't know. I never looked at it in that way. I'm just thinking in terms of the contract that they gave me was a policy that provided uninsured motorist benefits that continued to renew unless they non-renewed properly. If they end coverage before my accident date, there was no, I'm not entitled to anything under the contract. I'm not entitled to any benefits because they properly non-renewed is what, and yes, the answer to this question is they properly non-renewed, so there's no more
As long as you're
coverage.
still standing up, I'd like to ask an additional question. Who drafted the question?
Oh, the court did?
No input from either of you.
No.
That was regrettable. Thank you.
All right.
Thank you. The court will take this matter under advisement. Call the second case on this morning's docket, 103020 Busman versus Safeco Insurance Company.
Good morning, I'm Paul Hasty here on behalf of I think we're the appellee and cross appellant. We're the petitioner on the petition for review, and I'd like to reserve 5 minutes for rebuttal if I may.
All right, thank you, Mr. Hayes.
We see there are 4 issues here. The accident, as you know, occurred when Ms. Busman was involved in a motor vehicle accident in the state of Oklahoma when she was hit by a vehicle that either made a left turn or went left of center. She sued Safeco Insurance Company of America, who is the liability insurance carrier for the tortfeasor. She claimed underinsured motorist benefits. Safeco paid the policy limits on behalf of the other driver and took a release. Plaintiff then sued that insurance company, claiming underinsured motorist benefits. She said, under a policy issued to the bank that employed her and owned the vehicle she was operating at the time the accident occurred. Safeco admitted in the answer that it insured the tortfeasor, denied that plaintiff had a direct cause of action against us. The case proceeded through discovery. On the morning of trial, plaintiff offered into evidence or asked the defendant to stipulate to the American states or American economy policy on the bank, and defendant said it's not relevant. There's no claim on that policy. The court allowed it, and the case proceeded to trial, and there was a verdict, as you know. The Court of Appeals held that the issue was waived by not being asserted in the pretrial order. Plaintiff's position seemed to be that the identity of the defendant and proving coverage under the policy is an affirmative defense, and we deny that. We think that's wrong. It is always plaintiff's burden to prove the policy and to prove coverage under the policy. Those things were denied in the answer. They were denied in the pretrial order. The court held that because.
How do we tell, I mean, do we even know today whether it's American Economy, American States, or Safeco Insurance Company of America? I mean, when you look at the policy, you're really difficult to tell who's covering or providing which coverage.
You have to read it. That you're exactly right, sir. That is true. Allstate is a trade name.
Well, I understand that argument, but
All right.
but do we have any definitive proof in the record before us that Safeco is Insurance Company of America is not providing this coverage?
Yes, you have the policy.
And the designation on the deck sheet, is that where it is?
You'll find it there. Yes.
Because I think we've said in some cases that the deck sheet really isn't the policy.
Well, except it tells which company issued the policy. Yeah, if you just took the policy language itself without the declarations page, there would be you wouldn't know which insurance company was involved because it says we and you means the assured, we means the company issuing the policy, and look at the deck page and it'll tell you who that is. And I think you'll see with comprehensive commercial policies these days, more than one company is in the contract. For instance, American States might issue the contract for liability. American Economy would be the responsible insurance company for physical damage to a vehicle. But Safeco Insurance Company of America isn't in this policy anywhere. It is not.
Let me see if I understood you. So American States had the casualty and American Economy had the property?
That was an example. And I've got them backwards in this case or not, I can't remember. I'd have to look at the policy. I didn't bring it with me.
But there are different companies providing the casualty and the property.
That may happen, absolutely.
But we don't know if it happened here.
I didn't bring the policy, Your Honor, so I can't answer your question specifically.
Well, I think it make a difference, or potentially could, when you're looking at the 4908.
I agree.
It talks about providing policy coverage.
I agree. It could. It could. The other thing that troubles us greatly about the Court of Appeals decision is the court held that the offer of judgment would be used against the defendant to prove coverage. And the statute specifically says no to that one. If an offer of judgment is not accepted, it is withdrawn and can't not be used for any purpose. But that's what the Court of Appeals did. They relied on an offer of judgment. We think it was wrong. We suggest to you that on that first issue, this case should be reversed. There was no evidence presented by plaintiff that plaintiff wasn't insured under a policy of insurance issued by the defendant. Zero. The policy of insurance issued by the defendant was not in evidence. It insured the other driver. So the answer there should be, or the result there should be a reversal and judgment for the defendant. With regard to the second issue, the court instructed the jury that the jury could award damages for future medical expense. There was testimony by Dr. Ketchum that he recommended surgery, and plaintiff testified that she decided not to have the surgery. The downside or the possible consequence she thought was worse than the benefit she would receive, and so the evidence was undisputed. I'm not going to have the surgery. Dr. Ketchum testified, and the Court of Appeals found...
And she didn't get any damages for the one she said she wouldn't do. The jury didn't award any damages for the procedure she declined.
We don't know that.
The numbers match up.
The numbers match up.
Yeah.
Yes, sir. The Court of Appeals found that it was proper for the district court to submit the issue to the jury because future medical was, quote, possible. And we say that is never enough to satisfy a burden of proof of more probable than not. And that's the word the court used, was possible. And that's not enough. This should not have been submitted. The third issue is workers' compensation. Ms. Busman was in the scope and course of her employment at the time the accident occurred. She made a workers' compensation claim. She got an award and went through the appeal process. Her award was reduced, but she has future medical as a workers' compensation benefit. Both the policy and the statute, the mandatory uninsured motorist statute, 40-284, say the same thing. There is no uninsured or underinsured motorist coverage for something payable as a workers' compensation benefit. Period. Future medical for Ms. Busman is payable as a workers' compensation benefit because her future medical was left open. That's statutory. She went through the appeal process, and the decision on appeal says that. So if she has future medical as a result of this accident, some injury caused in it, she has a workers' compensation benefit.
Well, the UIM policy and the statutes speak to, quote, entitled to receive, end
Yes.
quote. Tell me why the ALJ's ruling entitled her to receive.
Because the future medical is left open. If she has future medical for injury caused by this accident, she's covered. She's entitled to receive it. It's the same burden she would have for future medical in a civil case. I'm sorry, ma'am.
What is her burden? Once that she incurs that future medical, does she not still have some burden to show it was causally related to the accident?
Yes.
And so it's not a given.
That's true. It's the same burden she has in a civil case. It has to be causally related to the accident. If it is, then she has workers' compensation benefits. If it's not, she doesn't, and she's not entitled to UIM benefits either.
And do we know, is there also, so that's one contingency, causation. The other is proof of what the actual cost of or the reasonable cost of the exam is. So that there are at least two contingencies so that we don't know exactly what she would receive. Does that matter?
I don't think it matters.
You think just the fact that she's entitled to the future benefit is enough?
Right, whatever the expense is. Yeah, in a civil case, we're guessing. Guessing's probably the wrong word, because if it's a guess, it doesn't meet the burden of proof. In a civil case, if there is sufficient evidence, we are making a judgment on what it will be. When there's workers' compensation coverage, you don't have to do that because it's not what it will be. Yes, sir.
And you're saying that even though it's an estimate of what will be the future, that if it's not causally related or it isn't a reasonable medical expense, then it wouldn't fit within the judgment here any more than it would fit within the workers' comp. Is that what you're saying?
Yes, sir.
Okay.
The same burden both ways.
The fact that they're coextensive is what wins your argument.
Correct. That's right. The last issue is the attorney's fees issue under 40-908. And we certainly agree that if you take some language out of decisions, out of context and out of the facts of the case, 40-908 applies to any policy in the world. That's pretty broad. Any policy that is issued that insures property in the state of Kansas.
No matter how ridiculous it may be, or some of us may think it may be, what we are looking at and what we've been doing recently is using the plain language of the statute, and it's all actions, and in which judgment is rendered against the insurance company on any policy given to insure any property in this state against loss by fire, tornado, lightning, or hail. The court in rendering such judgment shall allow the plaintiff a reasonable sum as an attorney fees for services in such action. And it really doesn't say that the property has to be related.
That's
right. Tell me how you can get there. How can you get in this language, even though we all know that wasn't what it was intended for? We know we're on a journey to Ridiculousville, and point of no return was Lee Builders. And I don't know how we can step back from that now, as the Court of Appeals dissent did, and make a policy argument when all the cases to this point have been plain language. You understand what I'm asking?
Yes, I do.
Okay.
Yes, I do, and that is a difficult issue for me. The general language of the statute, you're right, says any claim in all policies.
And it wasn't changed after Lee Builders. It wasn't changed after the case back. I can't remember the name when they came up with the bad faith, and this court said it didn't supersede 4908. that they applied to property versus casualty and didn't amount to type of loss, it was just the coverage. All of those cases that are leading to where we are today could have prompted the legislature to clean this up, and they haven't.
You're right.
And what do we do about that?
The statute was never intended to do this. That's the best answer I can give you. And you're right, it does lead to ridiculous bill. And the one that comes home to me the closest is, lawyers buy coverage on property because we have some computers in our office. Typically we don't have much property. It doesn't take much property to run a law office. But there's a part of the policy that provides me coverage as the administrator of the 401k plan if I somehow screw that up. So if an employee sues saying the 401k plan wasn't properly administered and I lost my investment and you're liable because you didn't administer it right, there's attorney's fees if I ever get in a dispute with my insurance company on coverage because I insured my computers if someone stole them. And that is ridiculous, Bill. I think you're exactly right. Here...
But that's what the plain language of the statute leads us to.
If you look no further than the general words of the statute, I think you can get to that ridiculous result. I really do. Here, Ms. Busman's not even an insured under the property coverage. She's not an insured person there. The bank is, because the bank owned the vehicle. She would be an insured under her own automobile policy if she bought physical damage coverage. And the reason it makes no sense is this. If you have a person who has his own coverage, and he's driving an older car and doesn't buy physical damage coverage, and he makes a UM claim as a result of an accident, he's not entitled to attorney's fees under 908 because he didn't buy physical damage coverage on the car. You take the same person who has a newer car, perhaps he finances it, so he has to buy physical damage coverage. Well, now he gets attorney's fees on the very same claim.
You don't even have to go there. This policy included the bank's building.
True.
And so under the policy, the building was insured for fire, even if it was just a straight fire policy. If you read this, it's in the disjunctive. So if there's any property in this policy, even if it's a package policy, then under the plain language, there's attorney's fees.
That's right. And I don't remember if it covered the real estate or not. It doesn't matter. It covered the car. And there's coverage on the car if it was damaged by hail. So, we can go on the different kinds of policies, and we think it just makes no sense at all. This is not a property damage case.
That's why I asked you before about the companies, because the statute speaks to coverage, and our cases have talked about, we're talking about coverage, not about type of loss.
That's true.
So does that impact anything, the fact that there was not coverage?
Well, here I think
this plaintiff for fire, tornado, hail, whatever the statute says.
I think it does here because she wasn't insured under the Safeco Insurance Company of America policy at all.
Well,
but even if she had the right company, no, she's not an insured person.
Well,
but the policy does.
But explain to me how we can feed that into 4908, that the coverage, the fire coverage, wasn't applicable to her.
Yeah, if I were writing the opinion, I wouldn't do that for this reason. And I'm trying to say this as I should. I think sometimes when a court tries to go too far to justify something, we wind up with bad law. Here, I think the right answer is this statute was never intended to cover anything other than property. This is not a property claim. I think that's the right answer. If the question is, but the broad words of the statute could be interpreted that way. Matter of fact, they say that.
First party property, because, that's the Court of Appeals dissent says, well, we can separate whether it involved property or bodily injury, but it still was a casualty claim in Lee Builders. It wasn't a property claim. It wasn't first party property claim. It was a casualty claim, and typically the insurance business has separated property from casualty being first person, third person.
True.
So I'm asking you what you're asking us to interpret when you say property. Are you talking about first person property or simply that property was damaged instead of a body?
I think the claim has to be property damage, as it was in Lee Builders. I'm not sure. Well, I think I disagree with the court's opinion on the earlier case, and like you, Your Honor, I've forgotten the name of it, but the court held that if it was a property claim, even though it wasn't hail, tornado, wind, lightning, that kind of things, the statute still applies. I don't think it was intended to do that either. I think the court looked at that and said, well, that's what the legislature said. I don't think it means that. I think it means a property claim. Thank you.
May it please the court. My name is Fred Spigarelli, and I represent Mrs. Busman in this case. God, it's getting old. It started in 2007, so we would like to get this resolved one way or the other. But to start out with, as I understand,
Actually, it started in 2005, didn't it? Wasn't she injured in 2005?
I think the case started, though. Yeah, I think the wreck was even earlier than that. But as I recall...
Tell me why it doesn't make a difference who the actual insurer is here, whether it's Safeco Insurance Company of America or American Economy or American States Insurance Company.
Well...
Why don't you have to sue the company, the actual company that actually issued the policy under which you're claiming, your client's claiming benefits?
Because we believe we did. And if they've muddled that in their policies by putting American States and the other insurance company there, Safeco, American States, and American Economy. But in the Court of Appeals decision, I think, you know, they looked at the policy real closely and said, well, there's even language in there, welcome to Safeco. We hope that, you know, that you'll be happy with our product. But not only that, if you will look into the policy, there's a section on there, whose name will be insured in driving the bank's vehicles, and Mrs. Busman, along with others, are in that.
Well, not really. If you look under the who is insured, you are covered for you for any covered auto. And you is the named insured in the deck, which is the bank, and then the subsection B says anyone else, and then it has some subsections, and one of them is your employee if the covered auto is owned by that employee or a member of his or her household. Now, your client was an employee of the bank, correct?
Correct.
And she didn't own that vehicle, did she?
No.
Did any member of her household own that vehicle? So that auto isn't covered for her, and she couldn't have collected the money. If the car was injured there or damaged in this wreck, could she get the money?
No, not for the cars. It didn't belong to her.
Well, so she's not covered for the fire, wind, etc. Coverage. She's not covered for that. She's covered for an uninsured motorist claim,
right?
But she's not covered for the property damage by fire, tornado, hail, or lightning.
I don't think so, unless the lightning hit the car that she was driving in, but I don't think so, no. But here's the way I see things. You know, the insurance company created this problem. The insurance industry created this problem with this product. You know what would have solved it? Would have solved things if they would have had separate policies, but they want to sell those comprehensive policies. I don't know what's behind it. Maybe it's a marketing tool, but it seems to me that why not just?
I tell you, it's a boon for the insureds because they can get it cheaper. If you buy separate policies, it's going to cost you more than if you bought a package policy. And so if you're advocating for that, you're actually advocating against the public.
Well, I don't know enough about it to really advocate either way, but as to the issue of 908, it seems to me that would have solved their problems. Because if she's driving a car that's owned by the bank with liability and underinsured and PIP on there, this would never come up under the policy that she has nothing to do with. We didn't create that.
It did come up, so let's move on to the future medical, if you would, and tell me why that the language that says entitled to receive does not encompass the workers' compensation award.
Because we got to look at the award, and it says she has a right to future medical treatment, and it will, on proper application, it will be considered. That's not a number in there. That doesn't say anything. That means I lived in these workers' compensation cases forever. That means you got to file another claim. You've got to put on another witness.
Because it's not liquidated, is what you're saying. That the workers' compensation litigation or proceeding did not liquidate an amount is why?
Well, it's impossible to do that. At that time of the award, all they can say is, the evidence shows that you may need another operation. There's two in the record in this case. One was for $15,000 and some, and the other one was $20,000, which you touched on in the other argument. And so she got on the stand and said, I don't want that first one that Dr. Ketchum said, but I'll sure take the other one. So to answer your question, the award just says it will be considered. Well, that's fair. That seems like a reasonable statement. It will be considered. But the ALJ may not say or may not go along with that. Maybe you're too late in time, or maybe we don't believe your doctor. And that's another thing. In workers' compensation, the insurance company picks the physician to do the surgery. What if she finds one? What if the insurance company finds one and says, oh, you've gone this far, you don't need another surgery? So where does it say that the plaintiff has to choose? I don't think it does. She has a right to file a claim in a civil action. She put on evidence. And
where it says is, doesn't the insurance policy say if workers' compensation applies, then we're not going to cover it?
I'm not sure about the word applies, but
entitled
they
to
get
receive
a
is
set
the
off.
language.
The
Entitled to
UIM carrier
receive.
gets a set off.
Yeah.
And they got a set off, $51,000. And the defense, Safeco now wants they want to take that offset and apply it for another $20,000, that there's no $20,000 in that award. So, no.
Well, that $51,000 is what was actually paid. And if you're taking only what's paid, then what's paid is not a future medical. Once it's paid, it's no longer a future medical.
No,
and so that's not what we're talking about here. We're talking about her I can't recall which one was it. The $20,000 was the one that she didn't say she would take, that they awarded. They awarded $20,000 in future medical. Is that correct?
The jury?
The jury.
Yes.
Yeah.
Yes.
We're talking about that $20,000. So you're saying that the injured person gets to select between workers' comp and underinsured motorists coverage.
Yes, for this reason, in this case. All I know is about this case. She did not get an award in workers' compensation for $20,000 or 20 cents. She didn't get an award for that. It said it will be considered. Well, what does that mean? And that's all it means, is that we may.
But is she entitled to receive in workers' comp?
You mean today?
No, is she entitled to receive that 20,000 in workers' comp, in the workers' comp case?
Well, I don't know. I don't think anybody would know that. That's up to the administrative law judge or the board. So, I mean, it is what it is. I mean, where does it say that she gets any money other than she can apply for it if she needs medical treatment? So, now, one other point on this, whether there was the right or wrong or the appropriate UIM carrier sued. That was never an issue in the pretrial order. It went to trial on a wreck. Basically, what we did is try to wreck as to and the only issues in the case was who's at fault, what percent, and what are the damages. The judge allowed him when Mr. Hasty says, "Well, I'm moving right now for a motion to dismiss because they've sued the wrong party." And the judge said, "No, we're going to go ahead for a trial. This is all new, but I'll tell you what we'll do. We'll have a trial. You put on your evidence or your motion." He filed his motion. I responded. I gave him the contract of insurance. He decided there was coverage. You know, you guys, you justices may be too young, but in the 50s, there was a quiz show called To Tell the Truth. And you'd have 3 contestants, and they'd get up there and start talking about themselves, but 2 were imposters. So at the end of the questioning, they'd say, "Will the real UIM carrier please stand up?" in this case. So they got all their names all over this policy. They got the same address and the same people it shows who are the corporate representatives, who they are. It's all the same people. Now, I would have liked to have tried that part of the case. I think we would have been successful. But just on the face of it, the trial judge said, this looks like I could have picked either all 3 of them or one of them. So, other than that.
Can I ask you about the procedural aspects of that? I understand the pretrial order that issue was not part of the pretrial order. But explain to me why being the wrong party is an affirmative defense, like under 6212.
You know, I don't know if I said affirmative defense. I don't remember the pleadings, but I did say this. At some point in time, they should have told us before the day of trial that, hey, by the way, we don't need a trial. You sued the wrong party. So that's all I can say.
I'm just trying to clarify how you're arguing this. I understand your argument. Hey, they didn't put that issue in the pretrial, and we tried it based on how it was pre-tried.
Right.
And it's too late now. I understand that argument, but there was some talk about affirmative defense, and I want to try to nail down what your argument was as to why that's an affirmative defense.
I don't remember that I said affirmative defense. I just said, isn't this late? But the other thing is, what I thought of, all that was cured. He filed the motion, and the court ruled against him. If the judge thought that there was something to this, he probably would have said, well, I'm going to set this aside, or at least hold it in abeyance, and we'll figure out who the right defendant is. That didn't happen. He didn't get past his motion. The judge entered judgment. I think on the face of the policy, what else are you going to put on other than the policy? So,
how do we consider that? What is our scope of review over that question, given the procedural posture?
Well, is there evidence?
We don't treat it as a motion to dismiss review. We would treat it as more like a summary judgment where we consider the evidence.
Very good question. Is there, I guess, wouldn't the substantial evidence rule apply? That is there substantial evidence that when the trial judge made a finding that there was coverage?
Treat it almost as if it was a court trial, in your view, on that issue.
I mean, it's weak because it came there, after the trial, and it's a motion, and we responded, and he decided it in our favor, but he had the policy. That's all I know about it. And so, but if you look at the policy, you can't tell who's the insurer on that. Probably all three of them, because they all have the same corporate office. They all have the same people that show who their officers are, CEOs. So I think that probably was a major issue in the court's thinking, the way I read that order. But anything else? I feel like I haven't said enough on this attorney fee business, but I guess that's all I have. Thank you. Thank you, Your Honor.
Thank you, counsel.
Mr. Spigarelli asked a rhetorical question. You know what would have solved this? The answer is, yeah, read the answer. This isn't the first case this court has seen where someone just doesn't read the answer. The answer said, we deny you are uninsured under the policy. We issued the the auto liability policy to the tortfeasor. We deny you have any direct cause of action against us. All you have to do is read it. And the pretrial order does show that was denied. Plaintiff claimed plaintiff was insured under the policy for UIM benefits, and that was denied. It's in there. The last theory he advanced is really interesting. He said they all have the same corporate officers. That theory is that if John Smith is the president of 4 corporations, all 4 corporations are liable for the breach of contract by one. And there's no legal basis for that at all. There's just none. And, Safeco Insurance Company of America is not mentioned anywhere in that policy. It's not there. There is a trade name, Safeco. That's like a trade name, McDonald's. That doesn't mean McDonald's Corporation is liable for a slip and fall that occurs in a franchisee. Allstate Property and Casualty Company is not liable for breach of contract by Deerbrook. They may have the same corporate officers. Allstate may own Deerbrook Insurance Company. But it's not defendant's burden. It is plaintiff's. And, Your Honor, you asked a question whether the insured has the right to, the claimant has the right to select underinsured motorist benefits or workers' compensation benefits. And I think that's, in my view, the wrong question. This plaintiff can get both under his theory. There's no provision in workers' compensation law that would prevent Ms. Busman, if she has future medical, from going right back to the administrative law judge and saying, pay it. There's no exclusion in workers' compensation for something that's paid as an underinsured motorist benefit. There is an underinsured motorist law in the statute. That's why it's there, so you can't get both. But that's the way it's set up right now. And I agree with Mr. Spigarelli on one thing. Right now, there is no number for future medical on her workers' compensation claim because she hasn't had any. And when she has it, there will be. If it is caused by, that's the causation argument. If it was an injury in the accident and the medical is necessary, then it's there regardless of the number. Could be $1, could be $1 million. Whatever care it is there. It won't be speculative at this point. Here, it was speculative because the doctor said or the Court of Appeals said it was possible. That was their word, it was possible. But even if you had evidence, more probable than not, that there was going to be future medical, and the jury could then put a number on it, it's still the same thing as workers' compensation, except it's not a definite number. There's nothing in the law that says that there's UIM coverage for future medical or anything paid by workers' compensation until it is a number. And this case is a good example because this lawsuit was filed before the work comp case was resolved. What happens if this one gets tried first? Then the theory that they're advancing is that it all is a UIM benefit, and then they can prosecute the work comp claim.
Do you
We say that
think
makes
you
no
would
sense.
have a future action for set-off in that case? If you were first, judgment was entered in the civil case, and then there's a work comp, could you seek a set-off?
I think, well, I thought I answered your question until you said set off, Your Honor. Would we have a claim? No, I assume we'd pay it. Assuming we're on appeal, it'd be done. Then could we sue to get it back? I don't know how that would happen. We know that if the company pays PIP and it should pay work comp, you can't sue to get that back. We have that case. So I think you probably can't. I don't know of a case that's ever tested that one. Thank you.
Any questions? Thank you. Court will take this matter under advisement, and the court will be in recess for 10 minutes.